So welcome to today's webinar, Rethinking Guardianship with Mr. Don Hoyle, the Executive Director of the ARC Michigan. This is part 2 of a 2-part series. You can find the first webinar on our website, MichiganAllianceForFamilies.org, or on our YouTube channel, youtube.com/Michigan Alliance. Welcome, Mr. Hoyle, and we're ready to pick up where we left off last time.
Thank you, Emily. One of the reasons this is an important topic in Michigan is this kind of information. When you look at this information, you might ask why it's not more up to date, and I can assure you that we wish it were more up to date, but the courts and states do not report this kind of information. Even in 1990, you see it's a limited number of states who posted how many guardianship filings there were in their state. There's no uniformity on guardianship. There's no Uniform Guardian Act, etc. And so one of the reasons that doesn't exist is because it's a state issue. It also means then that guardianship you obtain in Michigan doesn't transfer to another state. But that's a separate and minor issue, I suppose. But the reason we emphasize this in Michigan is just look at the number of guardianship filings in Michigan compared to any of the other states. And if we took a far more populous state like New York, and we said, why does Michigan far outpace New York in terms of the number of people, number of filings they have for guardianship, it does call into question why Michigan is such a user of this kind of outmoded form of controlling people. And what I'd say to you is, this happened in Michigan at the point where we did away with the ward of the state, and guardianship became far more popular at that point, and it's grown to a point that no other state comes close to using guardianship like Michigan does. So I'm asking people to question it. I'm asking people to say, why would anybody recommend this? And you could tell if you watched the first half, or you were part of the first half of this presentation, that there are all kinds of reasons why we ought to call things into question. I want to spend a little bit of time talking about the United Nations Convention on the Rights of Persons with Disabilities. As you may know, this treaty is up for ratification in the Senate now. The President signed it, but it's now before a committee, and we expect a vote at some point this year to adopt the Convention on the Rights of Persons with Disabilities. It requires a 2/3 majority of the Senate, a hard thing to get these days in any direction for anybody. But I just want to go through a little bit of this with you. Right in the preamble, the Convention talks about recognizing the importance of individual autonomy, independence, freedom to make their own choices. Those are all kind of the opposite of guardianship. And not only is it in the preamble, but it comes up other places. They define discrimination as the exclusion or restriction on the basis of disability, which has the purpose or effect of nullifying the recognition, enjoyment, or exercise of all human rights and fundamental freedoms. And I'm saying to you that is directly aimed at guardianship. Guardianship does exactly that. It nullifies the recognition, enjoyment, or exercise of human rights. It invests decision-making in a separate party, and in someone else, the guardian, and takes away people's rights to those kinds of things. And as I've shown you already, including their rights to their constitutional rights. I think that looking at the treaty says to you what the current thinking is about what we ought to be doing, and it's an attempt to make sure that people are equal under the law. If you have a guardian appointed, if you're the ward of somebody, you have no standing under the law. You have no standing. You can't go into court on your own. You can't do any of the kinds of things that the rest of the world can do, the rest of the people of this country can do. And we're saying that you should get equal protection, equal benefit of the law if you have a disability, and guardianship takes that away. And I think that legal capacity on an equal basis, that might not mean anything to anybody given any one day, But overall, we need to start thinking about people as our fellow citizens, as our equal citizens. And guardianship is the opposite of that. And this is, I think, where we come to the idea of supported decision-making, because it talks about access to people to the supports they require in exercising their legal capacity. It talks about supports. Again, I think that's contrary to guardianship, and as an outmoded form of methodology, guardianship doesn't take into account the way we view people now as people who need supports. And this statement is not from that. Obviously, that's over. The United Nations Convention is over now. But the majority of people who end up petitioning the court for guardianship for a person don't do it for some evil intent. They do it based on their concern, based on their desire to assist and guide somebody. But almost no one comes to the decision to seek guardianship on their own. Almost always, it's recommended by someone else. And so when someone else is recommending that to you, I think you ought to question that. I would ask people who recommend it if they were there when the statutes were written. I would ask them if they have even read the two statutes on guardianship. And I'd even go further and say, do you know what the effect of this is for the rest of the person's life? As I mentioned last time, guardianship is permanent, and a plenary guardianship, especially full guardianship. And that means that if you have a guardian appointed now, your chances of changing that in the future are really minimal. And so well past the parent's lifetime, someone else is going to be appointed guardian when they're gone. And that may or may not be a family member. More than half the time, the person appointed is someone who doesn't even know the person. And as I mentioned earlier, it's someone who has no legal obligation under the law to even meet their ward. So you can be guardian for a person and never have to meet them, never go to any meetings, never check on them, never do anything. Just instead make their decisions. This is that same Iowa case we talked about last time. And the drastic nature of guardianship, the ultimate power it implies for a person over another, is one reason the Iowa Supreme Court said, in making a determination, the court must consider the availability of third-party assistance. In other words, if there's some other way to do it, if there's somebody else around to help, there's no need to appoint a guardian. This is in that same case where they talked about the powers a guardian over a person with developmental disabilities had. They're far more than they would over people with psychiatric impairments, etc. So when they talk about this, they're saying, you know, that's so drastic, we should look around and see if there isn't somebody else to help them instead. And if there's somebody else to help them, there's no need to take their rights away. Utah, again, not a very liberal court, said, we don't care. This is so drastic. We don't care about the individual's ability to engage in a rational decision-making process. We don't even care whether they can come to conclusions or make decisions the way we want them made. That isn't part of whether we should appoint a guardian. The only time we should ever think about appointing a guardian is if bad decisions are being made. So as long as good decisions are being made, we don't care about what the person's capacity to make decisions is. And so the process isn't as important as the outcome. And this is from Tom Nerney, kind of the great granddaddy of self-determination. And he says the same kinds of things we talked about earlier, rejecting the idea of incompetence. We have to replace it with the idea of assisted competence. And this is the range of supports an individual with cognitive disabilities needs to receive assistance in decision-making that preserve their rights. And I think it's a kind of a foregone conclusion that people need assistance. We know they're going to need help. That help, however, can be help in making decisions without taking their right to make decisions away, without assigning second-class citizenship. This is my favorite. Pennsylvania Supreme Court said persons cannot be deemed incapacitated if their impairments are counterbalanced by friends, family, or other support. If you've got something else in your life, just like the Iowa court, if you've got something else in your life, there's no need to consider you incompetent or incapacitated. You have the help you need to get done what you need to get done. The Centers for Medicare, Medicaid Services are the people who control Medicaid from the federal level. And if you have a child of if you're the parent of a minor child, you may not know how important Medicaid is, but almost all services on the adult side now are through Medicaid. The federal government pays for 60% of everything in Medicaid, so the state turned all those services into Medicaid services in order to capture 60 cents on the dollar from the federal government. So that whether you talk about case management or supports coordination, you talk about vocational or services or residential services or any services you can think of, almost all now are through Medicaid. So Medicaid is really the driver of adult services. Medicaid doesn't talk about best practices. They use something called quality framework. And their quality framework goes through a process. So we first saw person-centered planning come up in the framework for quality, or the quality framework rather. And when it came up, they used Michigan's language. They still use language right from our statute. But what happened is first it came up as mentioned, and then it became more and more prominent until just this year. The latest rules from Medicaid say you must do person-centered planning. So just as it's been statute in Michigan, you have to do person-centered planning, and in our Medicaid manual in Michigan, now the entire country has to do person-centered planning in order to use Medicaid through the waivers that they provide. We're now seeing rights and responsibilities show up in that framework. If it follows the same path as person-centered planning, it's going to mean that protection of rights and decision-making authority is going to become even more important to Medicaid. Another reason, I think, to think about what we're doing and what we're going to do for the future. So talking to parents of children who aren't yet of majority age or who just recently got there is really important. And I think it's important also to say Medicaid is going to be looking for whether people have their rights protected and their decision-making authority protected. Michigan Mental Health Code says, and this is language, since I worked with the Arbon Commission, this is specifically my language. Guardianship shall be utilized only as is necessary to promote and protect the well-being of the individual. Necessary is one of those words that it either is or isn't necessary. It's like pregnant, you either are or you aren't. There's no gray in there. Something's necessary or it isn't necessary. And this is in the statute, but it's consistently ignored by the judges. And in fact, when the Blue Ribbon Task Force that I was appointed to by the Michigan Supreme Court came up with recommendations, one of our recommendations was that we would have a finding on the record of whether guardianship was necessary in any one instance or not. The probate judges opposed that. They didn't want to have a finding of whether guardianship was necessary. They just wanted to keep on doing what they'd always done, which is finding people incompetent, therefore guardians appointed. And the necessary was an important thing to us when we wrote this statute, and yet it's ignored, and not only ignored, but the judges themselves fought a provision to say you must have a finding on the record of necessary before you appoint a guardian. I'm just saying that it's in the statute and largely ignored. So we come to the point of talking about alternatives. As both the Pennsylvania and the Iowa Supreme Court said, if there's somebody else around to help, there's no need to do guardianship. I'd take it a little bit further. This doesn't matter for anything except the story, but I have Crohn's and unknown etiology, all that kind of stuff, and I don't know very much about Crohn's. What I really can tell you is most people die, most people who are, those who are diagnosed with Crohn's, some 5% die within 6 months, and then it goes down from there, but Eisenhower lived till he was 85. He had Crohn's. So that's kind of the range. They diagnosed Crohn's by ruling out everything else. So you go through a process and you spend a lot of time with people who have both the tools and the inclination of towards torture, gastroenterologists, and I'm speaking specifically about colonoscopies now. But when they rule out everything else, then you're finally left with Crohn's. And my doctor, who I knew before he was a doctor, and is my friend, we used to race motorcycles together before he was a doctor. He brought his textbooks when I was finally diagnosed by ruling everything else with Crohn's. He brought his textbooks so I could read up on Crohn's. And he pushed them across the desk at me, and I pushed him back and said, you know, you decided to become a doctor. I'm never going to be as expert about this as you are. And so why would I start to try to do this and have to look up every third word anyway and even to understand it? Why would I become knowledgeable about this when I'm going to depend on you anyway? Now, I can do that. I can say I don't know anything about Crohn's. I don't want to know anything about Crohn's. I ask my doctor, I said, David, what do I do? And he tells me what to do. And if it's not too onerous, I do it. If it's onerous and he gives me a certain look, I do it anyway, even though it's onerous, just because it's clear from the way he's looking at me that I have to do it. But I don't have to learn about Crohn's. If I had a disability, I wouldn't get away with that. If I had a disability, evidently, I'd have to know all about it and be able to weigh all the risks and of each step I took or each treatment, etc. But I don't know that, and so I don't have to because I don't have a disability. So I'm saying we should allow people with disabilities the same kind of option. Why couldn't they have an expert? You and I probably don't know how to read what comes out of the little black box, even if we had the equipment from the mechanics know. So we're reliant on somebody else there. We don't know what's going on inside our car. We're relying on someone else to tell us. I don't care what if it's plumbing, whatever it is, we're relying on someone else. And so we have advisors who tell us what to do. And we might get a second opinion or something, but we do that. We're relying on somebody else. We're not knowledgeable as ourselves, and yet we have a higher standard for people with disabilities. So I'm suggesting that people with disabilities should be able to use advisors, and especially if those advisors are their advocates as well, as I think my doctor, David, is for me. I've worked for a nonprofit organization now for 40-some years, and so in my personal life and my professional life, I don't know how to do this stuff where you use money to make money. If I came across a large sum of money, that would be, number one, a shock to me, but number two, I wouldn't have the capacity or the ability to use it to make more money. I'd have to rely on somebody who had expertise in that. And I'm saying the same thing is true for people with disabilities. They may have to rely on someone else. But the issue shouldn't be that they have to know it all themselves to an extent that we don't have to know it. Then we come to person-centered planning. And again, this is a statute that even CMS is using. And when we wrote this statute, the intention was that we not ask people to come up with informed decisions. But as you can see, right in the middle of this, it says, honors the individual's preferences, choices, and abilities. That's an entirely different way of looking at it. It puts the obligation, as I said last time, on us instead to determine what the person's preferences are and then follow those. And as I also said earlier, I consider that decisional capacity. If they can let us know what they like and don't like, that's decisional capacity. And I think that person-centered planning is an excellent way to have people have input and involve the person in decision making. Let me just step a little bit ahead here. I think if you look at the middle bullet here, this process of determining preferences and choices enhances the dignity and self-determination of individuals. It's a positive thing. It also is more reliable than having a single court-appointed person make all decisions with or without input from anybody else, with or without an obligation to even meet their ward. I'm just suggesting to you person-centered planning is a far better way to approach any of these things than a court-appointed guardian. So then we come to powers of attorney. I want to talk about powers of attorney a little bit, whether it's power of attorney, which is considered to be a power you give somebody now, or durable power of attorney, which can either be power you give somebody now or which has a springing action to it, which means it doesn't take effect until something else happens. Those are all interrelated, but they're not the same. The difference is the springing action. So what durable means is it goes past the disability. If it has springing action, it means it doesn't take effect until a later point. That later point is the point at which two doctors or someone, you have provisions for when it takes effect, and usually it's two other people determining the person is not competent, so at that point someone else has power of attorney. I don't find that to be useful for people with disabilities who are maybe considered not able to make certain kinds of decisions like informed consent you use in the medical community. Maybe they're not considered able to do that, so they might need someone who has power of attorney to do that for them. And just to erase some, can a person who isn't competent or incapacitated appoint someone else or give someone else their power of attorney? Well, they haven't been determined incapacitated or incompetent unless they've been through court. Only the judge can do that. So we can put that question aside, but what I will tell you is it's a much lower standard for determining whether a person can give someone else their power of attorney. It's a lower standard than other things. It's a standard known as of sound mind. And a sound mind talks mostly about not under the influence of drugs or somebody else, etc. It isn't really talking about things in the same way that when you talk about competence or incompetence or capacity or incapacity. And so it's pretty well understood that people can do those things, a number of things, if they're of sound mind, without necessarily being considered fully competent or having full capacity. We have in Michigan a statute about durable power of attorney for health care or designated patient advocate, and some of this when you get to that point, it's talking about usually what happens after a person is sick or has an injury or something, and is not expected to live. And there you're talking about whether I've given somebody what I want to have happen to me at the end of life, like I do want extraordinary measures, I don't want extraordinary measures, or here are some I would accept, here are some I wouldn't accept. So when you look at that durable power of attorney, we can do that. In fact, advanced directives are asked from you when you even have a minor procedure in a hospital. They ask if you have those, and they'll help you get them if you want to. That says what happens under certain circumstances, usually around the end of life. And so I go back instead to power of attorney, and we'll come up, I'll show you some forms for powers of attorney, some that I like and some that I don't, when we talk about what is possible in terms of making someone else providing the kind of informed consent that the medical profession might need. And I mentioned to you last time, informed consent is something we forced on the medical profession anyway. Protective orders. Many times I've heard people say the reason they got guardianship was to protect somebody. And I always scratch my head at that because it seems kind of incongruous that I would take somebody's rights away in order to protect them. And I would say that if we have the opportunity, we ought to use generic kinds of protection rather than say we're going to take somebody's rights away. And protective orders are one of those generic kinds of things. You used to see them in domestic disputes. Paparazzi are sometimes control with them, etc. But what a protective order does is protect the person from another person by a court order, saying that person must remain a certain distance from you or not have contact, not make phone calls, whatever it is. And so if we come to a situation where people are worried that someone's going to be a peril or predator to someone, what we ought to do is get a protective order. And then that forces them to stay away or do what we want without taking the individual's rights away to do it. It just seems to me more generic and more usual and not as long-lasting. It doesn't mean everybody has to stay away. It means that person has to stay away. It doesn't mean I take away your rights to do all kinds of other things. It only says that person we've targeted has to do certain things. And then trusts. And I'll talk about that later. I'm not going to spend time right here. We'll come to a whole section on that later. And contracts. We talked earlier about contracts being much broader and covering many more things than we think about originally when we talk about contracts where we're talking about something worth a lot of money. But I think that, let me tell you a couple of stories. The first story is Richard, who spent better than 35 years in one of our state's institutions, came out in his 50s, and we got him a job, in fact, at the Veterans Administration Hospital, ironing sheets with the great big machines. This is back in the days when sheets had to be ironed. But anyway, and starch too, by the way. But what happened is we found him this job, and he did it so well for so long that he actually saved enough money to buy a house. And we're not talking about a very big house. We're talking about a 600 square feet, but on 2 stories, so it's a tiny footprint on a lot. And you take out the stairway space, and it's even less room inside. But it was Richard's house, and he lived there alone, so it was comfortable there. I get a call one day, and I can't understand what Richard is saying to me. He's crying, and I would even call it blubbering on the phone, and I can't understand what Richard's trying to tell me about. And we do this for a while, and finally, I convinced Richard that I'll come by his house after work, and we'll talk about it then. And finally, he acquiesces to that and says, okay, or as best I can understand, said okay. As soon as I turned the corner to on Richard's block, I knew what the problem was. The south-facing roof and the south-facing walls on Richard's house were covered with solar panels. And I knew Richard couldn't afford to use solar heat or hot water or anything, or afford the conversion to it and all that kind of stuff. So I knew right away that somebody had sold him solar heat and panels and stuff, and he couldn't pay for it. And sure enough, inside were these dunning notices. He'd been getting phone calls threatening him, some threatening him in a way it shouldn't have been. They shouldn't have been allowed, and some they had a legitimate thing to threaten him about. They had a mechanic's lien on the house when they put the solar panels on. And Richard had these enormous bills that he wasn't able to pay. Now, if Richard had had a guardian, that contract would have been void on its face. However, we would have had to go through a process to say, so this mechanic's lien doesn't count, we'd have to go through a lot of machinations anyway to stop the process that was underway. Same thing when he didn't have a guardian. We had to go through a process, and things had to happen, and there had to be some phone calls, and I think probably fewer than if he'd had a guardian. But we won't know that because there was no control of this, no way you could test both things. But eventually, they came and they removed inside the house. They removed all the plumbing and everything else that went to his heat. But it wasn't worth removing the stuff that went to his hot water. So until the day Richard died, his house was heated by the water was heated in his house by solar panels. The heat no longer. But it's easy when someone can't read or understand a contract, then that contract is probably voidable. I've yet to see an instance when it wasn't voidable, and that and the salesman had to know what was going on. Now, this is the outcome for Richard. He got $204 back, which is evidently what he scraped together as a down payment on the solar panels that they insisted he provide. He got his $204 back, and I was told, I have no way to confirm this, I was told the salesman's looking for another job. Now, should he have had a guardian so this didn't happen? I don't think so. And so if the contract were voidable, we're in pretty good shape anyway. And I think an important piece to understand here is that neither Social Security nor SSI can be attached by an outside party. It can't be guaranteed or attached or anything else. It has to be held available to pay current bills. It can't be used or taken to pay past debts. And so that they could never lay their hands on that either. But I'm suggesting that they really had no recourse here because that contract wasn't valid. If Richard couldn't know or didn't know or understand it, couldn't read some parts of it. We had another instance where we had two guys who lived in their own apartment in Ypsilanti, but worked in Ann Arbor. And it required a switch of buses. And that switch of buses happened, or transfer from one bus to another, happened at a strip mall. It happened to have a large roof that stuck out over to protect from rain and everything else, I guess. But we don't know anything about what's happened, except one day one of the staff who worked with them at their apartment for some of the hours where they got support noticed this, in the mail came this big payment book. She claimed it was inches of payment sheets that they were required now to pay on a monthly basis. And it was from a fitness place. And just from the amount of fitness that they had purchased, we think they should have been allowed to move in there. You know, it was that level of stuff. The outcome in this instance, and it did take phone calls to accomplish this, and it did take a fax. But eventually, they had their $16 or $17 that they scraped together that they had in their pockets, and they got 2 free years of this fitness place. And this salesman, we know, was not kept on because he was never there again. So they did fire him. Now again, should Bob and his roommate have had a guardian? Because then this contract would have been void on its face. Well, I don't know that the salesman or anybody else would have known that if they had one. We don't generally put that on people's foreheads. So we'd have been through this process anyway. But as I say, I've yet to see a time when the contract wasn't voidable if people couldn't know or understand, couldn't read or understand what was in the contract. The only exception I would say to that is credit cards. They're an exception, and we'll talk about them later. I said earlier that there are lots of ways to deal with finances, and here are some of those. The Social Security Administration themselves will determine if someone needs a rep payee to handle their check, and that determination is made by the people who determine if the person has a disability or not. So it's not appealable. You can't change that. That's permanent. And who would that representative payee is also not appealable. So, for instance, if you have a child under 18 and you're going to apply for SSI, when they turn 18, what you need to do is go down and make sure that if a representative payee is going to be appointed, you don't have to indicate that one's needed, but if one is going to be appointed, that it's you. Otherwise, they have their list of things they go down, and it might be you anyway, but I would for sure talk to them about it. And so then somebody else is going to handle that money, not the person. You can also do limited bank accounts. And limited bank accounts could mean anything from there has to be another person's signature either on the check or even withdrawal slip, whatever, in order for the person to take money out. Or you could have a ceiling limit account. Only so much can come out at a time. Now, pour over accounts, which means there's only a certain amount goes in each day. Those kinds of things only happen if you're talking about a local bank, perhaps a credit union. The big multinational banks won't do that kind of thing for you. But I'm just suggesting here's some more ways, and we'll come to others in addition about handling money. The intentions of families when they become guardian, as I said earlier, nobody questions those. And the fact that someone else recommends it, their purpose, their intent when they do this is noble. Unfortunately, what you don't understand is, and what they don't tell people who recommend guardianship don't tell you is, now you've invited the government into your relationship with your child, not just into your life, but into the relationship with your child. Now, every year, you have to report back to the court about why you should be continued as guardian. And you have to report on what you've done as guardian. And who do you think has power in this this is now a three-way relationship. The parent or parents, their son or their daughter, their adult son or daughter, and the court. Who's the strongest in that relationship? Well, obviously it's the court. They determine if you get to continue with any relationship with your child. And I'm just saying to you, I don't think people recognize that when they seek guardianship, what they're doing is inviting the government right into their lives, or not just their lives, but into their relationship with their son or their daughter. And now they're going to have the approval of the court every year to continue in that relationship. I'm reporting to the court about your relationship doesn't seem to me to be the kind of requirement anybody would seek. And yet people recommend guardianship without understanding the change that it brings about in the relationship a person has with their son or their daughter. And almost always the court will continue parents until they're unable to do it anymore. But there have been instances where they've not done that, where someone has alleged something. And in order to check it out, the court removes the parents as guardian, appoints someone else as guardian, and then if there's anything else, that parent never gets back to the guardianship state. And in some instances, have been ordered not to have contact with their son or daughter anymore. So I'm saying satisfying the court isn't just what you report to the court, but it can include what other people report to the court about your relationship with your son or your daughter. So there are some real facets about this assuming guardianship that I don't think people take into account. But those who've been there can tell you they do have to report every year to the court, and then the court decides if they continue on or not. There are instances where people are actually told, and unfortunately this is by school districts or personnel at school districts, that when your child turns 18, you're not going to get invited to an IEP anymore. We're not going to send you any scores of assessments. We're not going to tell you about meetings or what's going on or any reports about your son or your daughter unless you become guardian. And I'm suggesting to you that they're flatly wrong about that. All it takes is a release of information. And I wouldn't even use this form. The schools have forms. In fact, if you have a good relationship with your school about the time or just prior to your son or daughter turning 18, they're going to provide you with their release of information. I think that's a far better thing to do than come up with your own. It's only if you have a different kind of relationship with your school where they're not going to provide you with that you might need to use this. Okay? So this says that the school has to release information to you. And of course it needs the person's signature. But I'm just saying this, if you hear from a school that they're not, you won't be invited to IEPs, et cetera, that's horrible on their part. However, what you have to ask them for is a release of information, or if they won't provide that willingly, come up with your own. And then they can't keep you from having the information about your son and daughter, getting scores, et cetera, et cetera. It worries me to even tell you about this, because if you have this kind of relationship with your school district, there's something wrong anyway. If they're saying those things to you, they're doing it, I guarantee you, without knowledge of what the final results of guardianship are past your lifetime, et cetera. They're doing it without knowledge of the statutes. They're doing it without knowledge of some other things that we'll show you as we go here. This is Michigan's Social Welfare Act. It's not in the guardianship statutes. It's in a separate place in the law. But if you look at the second piece here, it says if a person is unable to make medical decisions, then those medical providers are required to obtain written consent of an individual's nearest relative, guardian. So it's nearest relative, head of guardian. But if they have a guardian, then that person can do it as well. I'm just saying to you, there's a statute in Michigan that talks about medical consent. And if people are recommending or indicate to you in any fashion that you need to be guardian to give medical consent, I'm saying to you, no, you don't. And the only reason I would have the power of attorney of somebody is just in case you get to a situation where you're in another state or something else is happening, and you can keep that. You don't need to use it at all. Just instead, provide consent on this basis. I'm worried that when people recommend guardianship and they don't even know this statute exists, that means they're uninformed. And you are now going to be better informed than some of them are. If as I say, number one reason people seek guardianship is the medical consent idea. And in Michigan, we've obviated that. this statute precedes any of the guardianship statutes in Michigan. And it's still effective. The site is right there, Michigan compiled laws. So you can go get it yourself if you want to, or you can use this. I'm just saying to you, some of those who recommend guardianship don't even know what the laws say in their state. We can talk about that medical power of attorney a little bit again. I'm saying it's appointing someone to handle your medical decisions or support you in making medical decisions, and you can have it effective immediately. So there's no springing power. It doesn't take two people saying later, well, they need that to take effect now, or they're incompetent and they need to have the power of attorney established. It's not springing, it's immediate, okay? And it can be as broad or narrow as you want it to be. Patient advocate decisions in Michigan, if you've done this, if you've established a patient advocate, and then later a guardian is appointed, the patient advocate takes precedence over guardians. So I'm saying you have other ways of getting at some of this stuff without resorting to guardianship. I'm going to show you some forms that you can use for powers of attorney. I kind of like this one. It kind of says, what it says to me is, you know, I want my mom and dad to do what they did when I was 17 years, 11 months and 29 days old. That fact that I'm now 18 years old, 2 days later, doesn't mean I want things any different. So this is how I would start and say, they've always done this for me, I want them to continue to do it for me. And the notary public piece at the end is not necessary. If you think it makes it more powerful, go ahead. All a notary does is assure that the mark or signature has been applied by the person. They don't attest to competency or capacity or any of those kinds of things. So it's really, all it says is the person who did this, who made this mark or acquiesced to this or signed this, is in fact here Sam person. But it's not necessary at all. You also don't have to have an attorney to do this. You can use any of these. The ones I'm going to show you all were done by attorneys. So you can use any of these that you want. I'm not fond of the rest of them, but I'm saying to you, you don't have to be drafted by an attorney, or it can be. It can change it the way you want it. It doesn't have to have the notary public seal, but it can. And it will require 2 witnesses, and by the way, these usually are good for only a year, so you have to renew it every year. So here's one that I don't like, only because the things that are in there might as well have a guardian, right? Because instead, the person with power of attorney is going to make all these decisions, okay? And this is drafted by a different attorney, and it doesn't say springing in there anyway, but it does say durable power of attorney. That part doesn't matter unless it says springing somewhere. It only takes effect at a certain point in the future. But as you can see, the witnesses would say the person appears to be of sound mind and making this decision voluntarily, not under duress. A sound mind means not under the influence of drugs or another person or whatever. That's why it's worded that way. There are other powers of attorney that are longer than this that I'm not fond of either. That it would be hard for people to understand all the things that are in there, or agree to them even without understanding because they're so long. But Rep AE we've talked about already. I'm not going to spend any time. One of the things that's happened recently is certain nonprofits, especially those nonprofits that deal with people who are aging, have come up with personal money managers. So for a small fee, these people handle the finances of people. What we found in people who are aging is they're really tired of writing all those checks every month, and they wish somebody could do that for them. Now, some you can have automatic pay. Some you can pay online. But there are those that change a lot from one month to another that don't lend themselves to that. And so somebody has to manage that those payments for you. And that's what money managers do. The check goes directly to the money manager. They pay the current bills, invest any of the money if it's needed, troubleshoot any bills that seem large, etc., and pay those bills. And then the money that's left goes to the person, and that can go to the person on a weekly basis or on a monthly basis. If the person doesn't handle money well, maybe it goes the smaller amounts more frequently. Or it can go into a bank account or however you want it to be handled. I'm just saying this is a far better way to handle money because someone's going to have to do these things anyway, even if there's a guardian. Automatic bill paying, I talked about that already. Then we come to the credit cards again. The predatory practice of sending credit cards out to people, and then if they use them, the contract has been established and they owe you back at usually some exorbitant interest rate, all the money they've used. And they're typically small, $500 limits, etc. But we've been unable to work with credit card companies on anything except sometimes getting them to reduce the amount that has to be paid back. They won't forgive debts, and usually the amount of money is not worth spending attorneys taking them to court. Usually it's less than $500. But you need to understand how powerful credit card companies are. Unbeknownst to most of you probably, credit card companies went out a few years ago and got Congress to remove credit card debts from bankruptcy. So you can declare bankruptcy and get out of lots of your debts, almost all your debts, but you can't give up your credit card debt. You can't get out from underneath that because they were so strong. They got Congress to establish that credit card debt couldn't be removed through bankruptcy. I mean, just imagine the power that they've got to do something like that, but they did it. There are, however, two methods for opting out of getting future credit card offers. You can go online and opt out, and that's good for 5 years, or you can print out the forms that you get online and sign them and mail them back, and that's permanent opt-out. And you can do the temporary one while you're waiting for that to happen. This is the way it has typically gone. You learn that someone has gotten a credit card, and sure enough, they've used it and maxed it out, and now they owe money back. And in order to get it paid off, and you know, protecting people's credit evidently is important, although you wonder sometimes if that's really necessary for some people with disabilities. But anyway, you up the person, and it's excruciating from the small amount of money they get paying off these relatively large debts with interest accruing at the same time. And you go through that excruciating process, and people don't want another credit card because it's been so excruciating. However, if after the credit card's paid off and a few months go by, a person gets another one in the mail, they're liable to go through that same process again. And for those of us on the ground, that got to be an excruciating process over again. And so we really welcome this. And usually if a person's in the process of paying off a credit card debt and therefore they have less disposable income, not the $41 or the $64 that they're used to, then they'll agree that they don't want this to happen again and opt out. And I haven't yet to hear of anybody who got a credit card offer after opting out. Then let's talk about trusts. The things we learned from all the money we spent and research we did come down to two things, and this is the third. The first thing we learned is that, and this was unanimously agreed to by all the people who did the research, is that the best thing a parent can do when they're going to leave their son or daughter behind them is to leave their rights intact. So you don't run into having a stranger or a person who won't be involved in your son or daughter's life still acting as their guardian, making their decisions. It also means that they have equal standing under the law, equal protection under the law, and that they're equal citizens. The second thing they recommend, and this gets really important for person-centered planning, and it's going to come up again here now, is it's imperative that you make sure your son or daughter has lots of unpaid people in their lives. And most people don't think of that that's possible. Instead, many parents have gone through the process of trying to protect extended family from having to deal with their son or daughter very much, or their son or daughter being a burden to them. They've excused their neighbors and friends from having a lot of involvement or assisting with and supporting their son or daughter. That's just because we think our friendships, our neighbors, and our extended family evidently shouldn't have to deal with the reality of life that includes a person with a disability. When we talk about where are we going to find other people to be in their lives, that's the fertile ground. That's where you look first. And having been involved in a number of person-centered plans for the first time, people who were the friends of the parents, or people who were neighbors or extended family, get welcomed to this person-centered planning process, and tears just flow. And what's rewarding about it aren't the tears. What's rewarding about it is those people are saying, look, this is part of your life. We accept this part of your life too. And we thought you didn't want us involved. And so I'm saying that overcoming some of that is the way you start making sure other people are involved. But one of the things you have to be careful of is that some of those people involved are the same age as your son or daughter. Otherwise, like you, as parents, your son or daughter is going to outlive those people. And that isn't what you want. You want those people to be around for future person-centered plans and so on and so forth. And that's the way person-centered planning works best, if there are lots of unpaid people involved in the person-centered plan. If most of the people in the person-centered plan are paid to be there, it seldom is as rich or as useful a person-centered planning process as when there are other people who care about the person and who are supporters of the person rather than the system or receiving a paycheck from the system. And I just want to reemphasize that a little bit, that the two things we've talked about so far are a person's rights intact, and the research shows, and lots of people involved in your son or daughter's life, some of whom are the same age as your son or daughter. And they may be children of your friends, or they may be children of the neighbors, or as time goes on, it might be actual neighbors, but it also is true in extended family. Although a famous woman once said to me, the reason we have friends is to make up for our families. Never mind that, it's just an aside. When you come to a trust, here are the kinds of things we're talking about. The settlor or grantor creates the trust, the trustee manages the trust, and then the person with disability is the beneficiary. They receive the beneficial use of the trust. There are lots of trusts that we're talking about here. We're not talking about a support trust. We're not talking about a trust that will support the person instead of governmental assistance. What we learned in the process of examining all this, and I don't know what inflation has done to it, but what we learned in the process of looking at all this is that unless you can leave your child with a disability $1 million, and I have to imagine that's up to about $1.4 million now, unless you can leave them that much, then you are going to need to qualify them for Medicaid in their lifetime. Therefore, there are certain kinds of Medicaid qualifying trusts. I'm not going to talk about the last two here because that would mean you didn't do the correct estate planning and you died intestate, so that money went directly to your child and didn't go to a trust instead. Amenities trust, or some people call special needs trusts, are the ways to deal with what we're going to talk about. This is just how important fiduciary duty is. Support trust is when you want a third-party amenities or special needs trust. So now it's funded with your assets, but those assets don't have to be available until you die. And so this can be something you set up ahead of time. I recommend you do an estate plan, not just a special needs trust, not just a amenities trust, because you want to make sure that you've accounted for what's happening with your other children, and you want to make sure that the second of the couple to die means it takes effect. So there are things you need to do about estate planning that go beyond the special needs or amenities trust. The reason it's called an amenities trust is it buys things that governmental benefits won't buy. So they're typically amenities in someone's life. Governmental benefits provide kind of a subsistence level, and if you want better than that for your son or daughter, then you provide an amenities trust. And it provides for extra items or services, and if properly written, preserves the person's eligibility for especially Medicaid, because that gets to be really important. It gets to be so important that I would recommend that parents seek SSI as soon as their child turns 18. You can get it before that if parental income and resources are low, but otherwise parental income and resources are deemed to be available to the minor child. They're not deemed to be available to the adult child. The kind of Medicaid that comes with SSI is so superior to any other kind of Medicaid, and you want to make sure that happens as quickly as it can so they don't get ruled out for that kind of Medicaid by having other income from Social Security or some other source ahead of time. That's an aside here. I'm urging parents to seek SSI to get the kind of Medicaid that is the best kind of Medicaid. It comes automatically with SSI. So anyway, so the benefits of an amenities trust are these, okay? And when I look at the third one here, provides for the trustee to act as an advocate. Let's get into that a little bit. Pooled account trust, that's what happens if your son or daughter, if you haven't taken the right steps, you haven't done the right planning. Payback too, that's paying back Medicaid. But let's look instead at what the trust can be used for. We look at the bottom of the left-hand column. I think one of the best uses for a trust is what I've watched parents do, which is say, you know, after I'm gone, I want the same things to happen that happened when I was still around. I want somebody to monitor my son or daughter, where they live. I want to know they're safe and happy. And those are the two premises almost always that people want to know about their son or daughter for the future after they're gone. Are they safe and happy? And that is what's important to all of us about our children, I think any child, whether they have disability or not, but that's what we'd like to assure as best we can. And so while the other things can be used in a trust to do some of the other stuff, if Medicaid cuts out dental care again, you can use the trust for Medicaid for dental care. Lots of things that you can do here that aren't covered by governmental assistance, a TV set or cable hookup, whatever it is. But monitoring expenses are the ones I want to talk about. So what I've witnessed then is parents saying, okay, after I'm gone, I want somebody to go see my son or my daughter every week. And what it gets recommended then is that the trust finds somebody independent of the system, so they're not a provider, don't have a stake in what things are. They go and they do a visit. They write a report back to the trust. The trust sends that report back to all those people you have involved in your son or daughter's life. So those people now have not only a connection, but they also have the capacity to say if they see something in that report that they don't like, they can call the trustee back and say, investigate this further. Now, I'm saying to you that's something you can write into your trust, and therefore have them visited by somebody like you would have done before. I've actually seen people who are seen every 6 weeks by a nurse too, because what parents were worried about was medications. And that's what they were concerned about monitoring, etc. So whatever you would have done can be done through your trust by somebody else. And it can go then not just to the trust to sit on, but to all those people who care about your son or daughter, who are involved in their lives, or their supporters, who've been to person-centered plans, can all get that, and they can check it out. Let me talk about one more thing, and that is what's available in an emergency. Any good drafting of a trust will allow the trustee in an emergency to invade the corpus of the trust. Normally a trust works based on the interest it earns, but it doesn't have to do that. And also you can include provisions to say you can go in the corpus of the trust in an emergency. If you had a guardian and they saw the person was in an untenable, unsafe situation, what could they do? Well, the guardian could ask the system to please do something different and please hurry up and do it. Or they could use the money they have available. Oh, wait a minute, that's going to be $2,000 minus whatever the next check is going to be. That's what they've got available. What could the trustee do? The trustee could use the money is in the trust to pluck the person out, put them in a hotel room, and pay for 24-hour assistance for the person while they look for a better place for them, a safer place. I mean, I'm just saying to you, a guardian is stuck with the amount of money the person can have and still be eligible for Medicaid, and the limit there is $2,000 minus whatever the next check's going to be so it doesn't push you over 2,000. I mean, it's just an entirely different process. What's a guardian's obligation, supposedly, under the law? It's to do what's in a person's best interests. Nothing about what makes them happy. Nothing about what you would want for your son or your daughter. I'm just suggesting to you, guardians don't have any obligation about seeing that a person is happy or engaged or any of those kinds of things, or likes where they are. They don't have any obligation. They just do what's in a person's best interest. Best interest principle is not one you'd be willing to live by yourself. I'm guessing that you'd want something or things that make you happy or things that mean something to you, and is not just your best interest. A guardian acting that way is a whole lot different than a trustee who you've asked to act in a certain way, including assure the happiness of your son or daughter. And I don't know how to tell you that over the years what I've seen from the two different options, how important it is that there be an appropriate trustee and that they include other people. They too include other people in your son or daughter's life. There's a larger list of what a trust can buy. I invite you to look at that at your leisure. But let's go to self-determination just for a minute here. I'm not going to do this whole thing. Back when I used overheads, this was a simple principle. I could just put something up there and I could use a piece of paper to hide and show it. These are the principles of self-determination. Okay? Freedom, authority, support, and responsibility. This is the modern way of doing this. I said to myself, okay, what are the synonyms to freedom? Then I said, what would be the antonyms? Turns out the antonyms to freedom are synonyms to guardianship. And that's true for each of the other principles of guardianship. And you can look at this, if you're going to have this, you're going to look at it at your leisure. But it's, it's authority, same thing. Support, the same thing. I'm not going to spend a lot of time on this. As we were trying to make changes in the system and making sure we got institutions closed and everything else, we did focus groups to say, what do people want? And how does that compare to what they're getting? And to tell you the truth, person-centered planning stemmed directly from this. When people said, we want to plan our lives the way other people do. We want outcomes in our life. We don't want our goals based on what we can't do, based on assessments by a professional of what we're not good at. And what I'd say to you there is, what we send people to with disabilities to is working on what they're not good at. Working on feeding yourself because you have the residual capacity to do so, even though you can't take as many calories or any more calories than you're wasting by trying to feed yourself. I mean, it really is a process that we've set up for people to work on trying to make themselves normal or less disabled, instead of saying, well, at some point, when we get past their childhood, we'll let them have adult goals and wishes. So what people told us is they wanted to build on their capacities and abilities. They wanted to be able to gravitate towards what they were good at and not have to work on what they're bad at, goals determined by deficits. And person-centered planning is a direct outcome of saying, how can we get away from planning by interdisciplinary teams that really is the results in the tyranny of professionals, instead concentrating on the person. People said, we want our behavior seen as communication, not just as something that's maladaptive that has to be managed. If I run from somewhere, there's a good chance I don't want to be there. And we ought to see that instead of saying, whoops, elopement, we need to set up a plan to prevent that from happening again. And I'm not saying we don't provide for the safety of people. I'm saying we just should look at that and say, if they're trying to tell us something by their behavior, we damn well ought to honor that. People said they want support and personal assistance and choice and control rather than being seen as a person living in one of 6 beds in a home or a slot in a program. And instead of agency and provider staff, they wanted their own supports and personal assistance. It means somebody who works for you, not for the system. This is a friend of mine who teaches at the law school in Syracuse. I think this says it. Your impairment doesn't diminish your right to exert choice and control about your life or to fully participate in the economic, political, social, cultural, and educational mainstream of society. So quality of life includes people in your life. That's really important. I'll come back to that. But Rob Copeland, who from Vermont, said, you know, the real problem we face in the future, this was back in the 19th century, remember, before the change, the millennium, he was saying in the future, we have to worry about coercion and control, not just the other challenges we're facing. And I always include something Burton Blatt when I can. I just want to show you two more letters here before I tell you a story. And this is from the American Bar Association, and I didn't include their logo and all this stuff on it. And they did in partnership with the Administration on Intellectual Disabilities, which is part of the Administration on Community Living. And they invited me to a roundtable. They'd heard what I was proposing, what I was a proponent of, and they said, we want to invite you with some other people to talk about beyond guardianship. Not thinking about guardianship as a solution to anything, but go beyond it and talk about supported decision-making by individuals with intellectual disabilities. So the supported decision-making is now the byword. It's providing the supports people need, I think, through person-centered planning to get to the right decisions. Remember what the Utah court said. If you come to the right decisions, then the person's capacity doesn't matter. So the aim was to empower and support the decision-making of the population of individuals with intellectual disabilities, moving beyond the current guardianship model. Now that was October of 2012. This last October was the second. And here the Quality Trust convened it. But again, hosted by the American University College of Law. The American Bar Association was a party to it, as was the Administration on Community Living from CMS, Centers for Medicaid and Medicare Services, et cetera. All those people were involved. And we met again to talk about assistance in making life choices rather than overbroad or undue guardianship. And if you want to go to the Quality Trust, they have information to their website. They have information there, and including some real efforts at making sure we move to supported decision making. And some of the other efforts that I get involved in include speaking to the International Congress on Guardianship later this month, etc. But I'm just saying that the world is turning to this. This is what the change is. You saw it in the Convention on the Rights of Persons with Disabilities, and it's showing up lots of other places as well. And so this is how I see the whole subject. Every person can make choices and has a right to make decisions. People with cognitive or intellectual disability express those choices in non-traditional ways. And any legal system or proceeding which deprives an individual of their right to be accommodated and supported, it makes that person vulnerable and deprives them of their rights. Our obligation is to find the best ways to provide the accommodation and supports a person needs to maintain their autonomy and make decisions. I was asked in the middle of the focus groups that I told you about a little bit earlier. I was asked by the person who did the focus group. His name was Paul Stepanski. He used a pointer, had a pointer on his head and a board, and I was his reader. And he turned and asked me this question on behalf of the group. He said, "How would you like it if through that door over there came somebody you didn't like, and they were going to be in charge of you for the next 8 hours, tell you where to go, what to do, what you had to eat, what you had to watch on television, when you were going to go to bed. And if you needed it for your personal hygiene, that person who you didn't like was even going to touch you in some intimate ways. And they were going to come back tomorrow and the next day and next week. Far as you could see in your future, from 3 o'clock to 11 o'clock every day, you're going to be under the thumb of this person you didn't like. How would you like to live like that?" And I can tell you, as I age, I have a head start on all of you, I'm sure. It's not acceptable to me. It's not acceptable for people I care about either. Then he said, okay, now imagine that through that door at 3 o'clock comes a person you don't think likes you. And they're going to be in charge of you. Tell you where to go, what to do, when you go to bed, what you're going to eat. If you need it for your personal hygiene, that person who you don't think likes you is going to touch you in some intimate ways. How would you like to live like that? It was going to happen tomorrow and next week, as far as you can see in the future, from 3 o'clock to 11 o'clock. So I'm saying we have to go further. We have to say, and I don't just mean this for people who are mildly impaired, I mean for people who are significantly impaired. People who are the most impaired. In fact, I mean it for everybody. It should be our obligation. They shouldn't have to prove some capacity to make decisions or anything else. We should be involved in helping them and assisting them and supporting them. And I don't just mean this for people who are mildly impaired. I mean for everybody.
Thank you so much for your presentation today, Don. If anybody is interested in getting in touch with Mr. Hoyle, his contact information is available there on the screen. If you have follow-up questions or would like to contact Michigan Alliance for Families, here's our contact information.